A lawyer is about to put something sensitive into an AI tool, maybe an unfiled patent application, a client's financials, or a trade secret analysis. And they do the responsible thing. They stop and they ask, is it safe to put this here? The answer comes back from someone at the firm or from the in-house legal team. Don't worry, we are on the enterprise plan. Our data is private and it is not used to train the model. Half of that is correct. The other half was never asked, and it is the half that decides whether a copy of the client's information is sitting on a vendor's server tonight. This is the agentic lawyer. Today, the difference between no training and no retention. They are two different promises, and the difference decides your confidentiality posture. We are on Enterprise Bundles, two separate guarantees that people hear as one. The first is no training. On the business tiers, the vendor does not use your inputs and outputs to improve its models by default. The exception is opting in. And the most common opt-in is the feedback button. Both OpenAI and Anthropic treat a thumbs up or down as permission to use that exchange to improve the model. Short of that, the instinct that enterprise means they are not learning from my data is correct. The second is no retention. The vendor does not keep a copy of what you typed. This is a different promise. It is not the default anywhere. And on the chat products most lawyers actually use, you frequently cannot buy it at all. Zero data retention is a separate, request-gated arrangement that mostly lives on the API, the programmatic channel software uses to call the model, not the window your lawyers type into. So a firm can be fully covered on training and fully exposed on retention, and most lawyers cannot tell you which they hold. The product name answers the training question and stays silent on storage. Here is where the three tools most firms use actually stand. Off the shelf, with no addendum signed. First, Claude Team and Enterprise. No training by default, but yes, it keeps a copy. Retention is configurable, and the chat interfaces are not eligible for zero retention. The copy lives on Anthropic's servers. Next, the ChatGPT business tiers. No training by default. Yes, it keeps a copy, and an admin sets the period. Zero retention is API only, and you have to request it. The copy lives on OpenAI's servers. And then Microsoft 365 Copilot. No training by default. Yes, it keeps a copy. It is logged for audit and e-discovery, but you set retention yourself through Purview, and the copy lives in your own Microsoft 365 tenant. Look at that last line on each card. It changes the legal analysis, and almost no one thinks to ask. With Claude and ChatGPT, the retained copy sits on the vendor systems. A third party is holding your client's information under contract. With Copilot, the copy is logged inside your own tenant, under your own retention policy, in tools your firm already administers. Those are not the same confidentiality posture. They lead to different answers on who you have to trust, what you may have to disclose, and what you can promise a client. Same prompt, different exposure, decided entirely by which tool someone opened. This is a legal question, not an IT preference. Knowing what your tool does with client data is part of competence, not a nicety. That is Model Rule 1.1, Comment 8. For patent practitioners, the same duty applies before the USPTO. The duty to make reasonable efforts against unauthorized disclosure assumes you know where the information goes. You cannot take reasonable steps to protect a copy you do not know exists. It has sharper teeth for IP work. A retained copy held by a vendor under confidentiality terms is not a public disclosure. The provider has not released it to the world, and a trade secret survives. But trade secret protection does not turn only on whether the secret leaked. It turns on whether you took reasonable measures to keep it, and that is judged by the strength of the measure, not the logo on the contract. A reputable enterprise tool is a reasonable measure. No training, access controls, a data processing agreement. Using it for sensitive work helps you. The thin case is the opposite one, leaning on a consumer default that trains on your inputs and keeps them under no obligation of confidence, then calling that your protection. The element is not about handling crown jewels differently from routine matters. It is about whether the secret actually got a real measure, and just as practically, whether you knew enough about the tool to prove it. So, what to do? 3 questions, answered in writing, not from memory. Question 1, Does our tool train on our data? On a business tier, the answer is almost certainly no. This is the part you already have. Question 2. Does it retain our data? Where? For how long? And who controls that copy? This is the part most firms have not confirmed, and the answer differs by vendor. Question 3. Is there a zero retention path? And does our actual work run through it, or through the surface it does not cover? It is a short email to whoever owns the AI vendor relationship. Send it before the next privileged matter goes in the box. The written version of this piece with every source linked is at theagenticlawyer.com. The link is in the description. The next piece in this series runs the other way. The most capable models often will not let you have zero retention at all, on any tier. If you practice at the intersection of IP and AI, the newsletter is where this lands first. Educational only, not legal advice, and no attorney-client relationship is created. Views are my own.